Good morning or afternoon, everyone, depending on where you are. This is Kat Eaton with JBS International. Thank you for joining today's Ask an Expert office hour session with the Honorary Lawrence Gendler. Before we begin, we'd like to review a couple housekeeping items. Today's presentation is intended to be an interactive discussion between the presenter and the participants. However, we ask that participants please keep themselves on mute unless requested to unmute and use the raise hand feature in Zoom to indicate that you have a question. We also encourage you to turn on your video, especially when asking a question to the presenter. In addition, please feel free to use the chat feature to interact with the presenter and ask questions as well. Open your chat window by clicking on the chat icon located at the bottom center of your toolbar window. Near the end of the session, we will request that anyone who wants to receive additional information and resources related to the session send their email in the chat, and we will add you to this office hour sessions listserv. There will be a link to a brief post-event survey sent in the chat at the end of the presentation, and we would greatly appreciate it if you filled it out, as this will support future development efforts. If you experience any technical issues during the session, please message us using the chat feature or email us at obc-tta@jbsinternational.com. Today's office hour session is being recorded for sharing. The recording and presentation slides, along with any other resources, will be made available to the OBC-TTA listserv in the coming weeks. Now I'd like to turn things over to Jenny Cole-Mossman of JBS International, who will introduce our expert for today.
Thanks all, and thanks for those of you that joined us today. This is our inaugural office hour. So we're trying this out, and we've got another one coming up that we'll put up the information at the end. But today I'm going to introduce to you Judge Gendler, who is going to talk to us. We got his bio up here. He is retired now. But was a full-time juvenile prosecutor and then the second juvenile court judge appointed in Sarpy County. He was the project chair for something called Through the Eyes of the Child, and that's what we're going to be talking about today. And you can ask any questions afterwards, but I think that when we think about what judges do, we think about making decisions and hearing evidence and writing opinions, and we don't often think of judges as conveners. He is going to talk just briefly about a project that we had in Nebraska through our Administrative Office of the Court and our Court Improvement Project that helped pull together multidisciplinary teams across our state. So he will talk for just a little bit and do an introduction, and then we will open it up for questions. We don't have a ton of folks on, so I'm pretty sure we can just unmute and ask questions when we get done, unless we have a whole bunch more joining us. But I am going to turn it over to Judge Gendler.
Thank you. Thank you all for joining us today. Again, my name's Larry Gendler, and I was a juvenile court judge in Sarpy County, Nebraska. Before I start, I just want to thank all of you for all that you do. You're the reason why the system works, and I appreciate all that you do, even though I don't have a chance to meet with you personally. I know all of you have made a difference. I was very lucky, to be honest with you. A little over 16 years ago, our Supreme Court decided that we needed to start an initiative in the state of Nebraska called Through the Eyes of the Child. And this was an attempt to establish collaboration teams across the state, initially assigned to work on child abuse and neglect, and then we expanded to juvenile justice. So we had our initial meeting in Nebraska City, and we had all the juvenile court judges and the county judges there. In Nebraska, there are 3 counties that have separate juvenile courts. The other 90 counties have county judges who hear juvenile cases as well as other things. And in addition to those folks present, we also had prosecutors. We had defense attorneys for parents, guardians ad litem, caseworkers. And we had a lot of speakers lined up over those 2 days. But the bulk of the work started in a resource guideline that we had borrowed heavily from the National Council for Separate Juvenile Court Judges. And the guidelines were divided into different subject areas, beginning at the beginning of a case, in terms of timelines, when information was provided to the court initially, what information courts needed, how that case progressed, how soon adjudication hearings occurred, how soon dispositions occurred, further reviews, permanency reviews, exception hearings, all through TPR, in fact. And the guideline was approximately 25 pages, and we can get you a copy of that if you'd like that sent out to you. So what we did as teams was just kind of discuss what areas we thought we were deficient in first, and then work on those. And then we reported out. We had about 400 people there. We reported out to everybody in a larger group. And as part of the initiative, we knew that we didn't want everybody to work on the same thing because different jurisdictions have different issues. So part of my responsibility was to go around the room and meet with different folks to discuss what they wanted to pick as their initial 2 or 3 issues to work on. And it was a good education for me because I quickly realized that those of you in rural areas don't have near the resources you need. And collaboration is something you just naturally do because of those lack of resources. So after that initial 2-day meeting, we had team secretaries assigned for, we had roughly 25 teams, team secretaries assigned from each team. There were monthly phone calls with those team secretaries to gauge the progress. We encouraged the teams to meet as often as they thought necessary, but at least quarterly, to discuss their progress. And then every year we had 4 regional conferences. Each conference was the same material, but we did it in 4 different locations across the state to make it convenient for folks to come, and they lasted 1 day. We would have every 3 years a summit where we would set aside roughly 2 days for a statewide conference in Kearney, Nebraska, which is central Nebraska. And again, we made time for the teams to meet individually as part of those conferences to discuss their progress and things they wanted to work on. So I just want to give you a couple ideas of what came out of these initial few years of the initiative. Front loading the system, having mediation occur before the first hearing, before the first removal hearing, to determine what resources could be put in place, as well as if we could put the child back home with support services or children back home with support services. And as a result of those efforts, we actually drafted legislation that was passed by our legislature that codified these mediation services, that ensured that anything said during these mediation sessions were confidential, was confidential, excuse me, and also set out a process for how they could occur. And then we expanded that mediation for permanency hearings. So frequently now in Nebraska, before a permanency hearing, there'll be a mediated session, perhaps 2, to discuss what the permanency plan should be, and if there are deficiencies, what needs to be addressed before a TPR is filed. And that's commonplace quite often in a number of different jurisdictions across Nebraska. And I should back up, I'm sure this is typical in other states. Our Supreme Court has mediation centers they've established across the state within mediation districts. So for example, Omaha is one mediation district. I also did work in Cass County, which is a county just south of where I was. And their mediation district, the home office was in Beatrice, which was about an hour's drive away, but these mediators would typically travel. So we utilize these mediation centers across the state, but there are also other options. So for example, in our county, we use the CASA people, our administrator, at those initial front-loaded hearings to discuss what options might be available for families. And we also took the time to try to introduce folks to the parties because, you know, parents come to court and they don't know anybody, they don't know the system, and of course they don't trust anybody. So it was really important for us that we established some trust early on that they trusted us, trusted the process, and could feel free to discuss in these mediation sessions what their feelings and thoughts were without it getting back to a courtroom, and maintaining some confidentiality. In addition to those two things, different types of treatment resources were developed across the state because of these efforts of these teams. And today, these teams are an active part of their jurisdictions, and they still meet regularly. There are some teams that have enormous numbers. I'll give you an example. In Lexington, Nebraska, where we had gone, a town of a community of about 10,000, a county of probably 15,000, they'd have 25 people show up for a team meeting. So I can't say enough about the county judges because they have so much on their plate, and those people that work in those jurisdictions, because they have to travel great distances and they just lack the resources that many of us in the eastern part of the state, the metropolitan part of the state, took for granted. But as I mentioned, I was lucky. I enjoyed it. I got to meet a lot of judges and a lot of other professionals as a result, and I learned quite a bit from it as well. So I want to open this up for questions to give folks a chance to respond, and we'll go from there.
And you can just unmute and ask a question if you have one.
I can go in somewhere.
The first thing that pops to my mind is like, so like our system in Nebraska was like set up and formalized, but if folks wanted to like engage their judges in doing some convening, like how do they start doing something like that?
So I was also on the Judicial Ethics Committee for a while, and I chaired it. And at the time I was on the committee, collaboration projects really were not part of judicial ethics. Not that it was prohibited, but it really wasn't encouraged. And there was a model judicial ethics code that was passed, I'd say 15 years ago now, that encouraged collaboration and encouraged judges to be more actively engaged in problem solving. Problem solving courts are a good example of what came out of those ethics rules. So it's much easier now ethically for courts to convene meetings with professionals. You still can't talk about individual cases because that's separate, and that would be a violation. But you can certainly talk about process and procedure. You can have outside people come in to educate the committee or whatever the group wants to call themselves. Frequently, our teams would call in outsiders to present on things such as how to use a psychological evaluation, what to look for in a psychological evaluation, what to look for in a chemical dependency evaluation, the kinds of treatment available in those areas. We had school people come in and talk about the need to address screening for deficits for those youngsters that are 0 to 3, what programs and services were available for them, transitioning those services to an IEP when they turn 3. In Nebraska, we were lucky because those services were also covered. That's not mandated by federal law, but federal law does mandate that those 0 to 3 screenings and assessments occur along with a coordinator for those services if services are recommended. So all of these things occurred under the umbrella of the initiative and of these teams, but nothing prevents a group of people to come together to discuss what options may be available in their community and how to improve their system. And as I mentioned, the Judicial Ethics Code now, and this has been adopted in all the states, encourages these kinds of collaboration meetings. And as I mentioned, problem-solving courts are really a good example of that. Other questions?
Judge Gendler, I've got one, and it's one that I actually, when we speak with several of the grantees I'm working with, they're always sort of looking for, I guess, messaging or how to approach judges and the messaging that would be maybe helpful or resonate with them when they want to sort of switch focus or bring attention to an issue. And so just curious about, your experience with the Through the Eyes initiative. Were there certain messages or approaches that engaged you or hooked you in more? Maybe it was more of sort of a voluntold thing, but just curious, like if you had any tips for folks as they're trying to connect with judges and really help them sort of see the different sides or their role in a particular issue.
Yeah, that's really a good question. And judges, varying personalities, right? I guess I hope that all of you work in jurisdictions where a judge is approachable. The judge's staff can be a huge benefit to people as well. Sometimes judges are busy or they're unavailable, but the staff can make them. There's a bailiff, there may be a secretary. We were pretty, how do I say this, informal in our approach. I wanted people to contact me if they had questions. We couldn't talk about specific cases. We met with caseworkers on an ongoing basis just to introduce ourselves and to make sure that they knew who we were and we knew who they were. Same with probation. So one way to start maybe perhaps is just to request that a meeting be convened so that people can just meet each other. And I know in some jurisdictions that are larger, that may be difficult to do in person, but you can certainly do it by Zoom. And judges generally want the ability to communicate with other people so they're not behind this dark cloak of mystery. And I've always told people not to be afraid to approach the system. And the judge is just one person who's part of that system. Because all of you have something valuable to contribute. And unless it's communicated, courts aren't going to be aware of it. So I suggest that people approach the staff, suggest that there be meetings. Same with CASA. We met with our CASA folks a couple times a year. We would meet with providers on occasion. And we were small enough that we could do this fairly easily. School people are another important component. I think it's important that courts know who superintendents or principals are, not that you're going to talk about specific cases. So that's another group that could assist in convening a meeting. And then generally, once you get the meeting together, ideas get generated and there's next steps, I guess, for lack of a better word. I hope I've answered your question.
Yeah, no, that's very helpful. And in fact, it leads me to another question too about sort of one thing that you mentioned was the process for sort of identifying deficiencies or areas of focus. And, in my experience, once we start talking about deficiencies, partners can sort of close up and especially when they are sort of areas of collaboration or systems where a certain entity maybe owns some of those deficiencies more than others. And so just curious if you had any strategies for how to approach those in a way that encourages people to be open, transparent, and maybe even to some degree vulnerable in discussing some of these tricky areas of collaboration and multidisciplinary work.
Well, deficiencies aren't because of a lack of effort. That's really important to stress. In my experience, and I'm sure everybody else is here, folks are trying to do the right thing. And these deficiencies aren't a result of any personal failures. They're oftentimes a result of system failures or a lack of resources or a lack of communication and difficult cases. So I mentioned that it's really important that clients trust the system. I think it's really important that those that participate in the system trust it as well. And I hope nobody works in a system where fingers are pointed and people are accused of doing something wrong, because I really do think people are trying to do the right thing. So again, setting the proper tone is really important. And I think everybody who participates can help contribute to that. But I think it's rare that a judge would look and suggest, well, somebody's a failure. I just don't think that's how the system should operate or does. These deficiencies occur through no fault of anyone. They're just difficult issues to address. But I do think convening groups and meeting is helpful. There is an awful lot that we accomplished as a result of our team in SARPI. I can give you several concrete examples. We moved from initial filing to adjudication in much quicker times than we did before the initiative. We typically 60 days, maybe 90 in some circumstances. Sometimes we could proceed to immediate disposition because we had front-loaded the system and all those resources were in place, and we knew what we needed to do for next steps. So there was no reason to bring people back to court for disposition. We often had reviews every 90 days because we were able to get kids back home more quickly. We also discovered in our analysis that if a CASA was appointed, those youngsters went home 2.5 months earlier on average than the general population. So that told us we needed to make sure we got CASAs and got them appointed. So little things like that just contributed immensely to our timeline and case closure timeline. And everybody has a contribution to make. And I think once they're heard, as I've mentioned, our experience was good things happened.
You know, I think what you said about setting the tone, like that is really something that a judge as a convener, you know, first of all, you can bring people to the table because people will show up for you, but also setting the tone because you, by virtue of your position, are in a position of authority. So setting that tone of not saying like you messed up or it's probation's fault or it's HHS's fault, but bringing that tone, I think really helps.
So does food, by the way.
Yeah.
We always made sure we fed people.
The potlucks, tell them about the potlucks.
Oh, in Lexington, they had people brought, I bet 15 dishes. The judge would make the main dish and everybody would bring the side dishes. They ate better than anybody in the state at their team meetings, I think. But we always make sure we fed folks. And we typically did it over the lunch hour. That seemed to be the most convenient time for everybody. And like I said, I learned a great deal out of this process. The other thing that I think we can take advantage of with judges, in my case, for example, I worked in that county as a prosecutor, and I started in 77 as a law clerk and 78 as a lawyer. And I was in that building for 44 years. So I knew a lot of people in the community just because I'd been there so long. And a lot of the judges that I'm sure you work with have been part of that community a long time. So there are some relationships there that you can take advantage of in terms of who they know and who they can bring to the table. And that can be a valuable resource as well. As I mentioned, I was really lucky because I knew all the superintendents in the county. I knew many of the principals. I knew all the police chiefs. I knew others, therapists and other treatment facilities that it made it easy for us to invite them because we knew them. And I'm sure the same applies to all of you. There's a lot of folks that you know in your system and in your area that you could invite that could make a difference.
You know, I'm just thinking too, like when you were talking about the information, so a lot of the grantees like are wanting to give information to courts about the impact of substance use, or, you know, maybe what treatment needs there are or things like that. And that was the nice thing about the eyes is we did have those educational components and everybody heard the same thing. Like if you went to a meeting and there was a presentation, they all heard the same thing and they all had a resource then for that, whoever the presenter was, because usually they were part of the team.
Right.
They were
Well, in
local
your case,
leaders.
for example, you lectured on trauma with regard to young ones.
Yeah.
And there were handouts. And as part of that process, we also had books. That's another thing that might be helpful in your communities, to have book drives for a judge to give books out to kids that come to court. We tried to make sure that every child either came to court or met me. Sometimes I would meet them in my office on the record with the guardian ad litem present. I always had counsel's permission beforehand before we did that. I never had anybody object. I was careful not to answer or get into any questions that related to some controversial things or things that were contested. But having those kids see the courtroom, meet a judge, meet other people, help relieve some of their anxiety. And I think it also allowed me and others to get an idea of how they were doing, just generally. Are they going on sibling visits? Are they doing well in school? Do they want to go to prom? Do they not have the money for prom? Is there a soccer camp or something else they wanted to do that's been overlooked? The little kids would show me their new tennis shoes, their new shoelaces. They would bring me art projects. But I found it really rewarding. And I'll give you just one example. We had 3 kids that would always come to court, and they wanted to see me prior to a hearing, which was a bit unusual. And the lawyers all said that was okay. So we went in on the record with the guardian ad litem present, and they told me that they were being essentially abused in their foster home and were afraid to tell anybody. So the tenor of that hearing changed dramatically. And we were able to get them in a different placement. But for some reason, they were afraid to talk to people, but they weren't afraid to talk to me, which was a good thing. I still have contact with 2 of those 3. They're doing really, all 3 are doing well. 2 of them have graduated high school. And one of them is currently in college. The other one attended a community college, and he's doing great. So that's another part of this EYES initiative, was trying to encourage children coming to court or meeting the judge. That was something that we thought statewide was pretty important. There's a judge in McCook, Nebraska that hands out a pillow to every child that comes to court. She read in an article that a lot of youngsters don't have good pillows. So she ordered, and I'm not exaggerating, I think it was 40 pillows from Kohl's that were on sale, and had them stacked in her office. And every child that came to court got a pillow, whether they were a probation case or a child welfare case. But the book thing was something that we did that got to be pretty popular. So all the kids that came to court would go into the conference room and pick out a book. And we also gave books to parents to read to their infants. So that was something else that we were able to do. And all that was through the initiative.
Well, I think all of this is like about having real relationships. Like when you're meeting regularly and you know people, you know their job a little bit better, you have perspective and you trust each other's opinions. And I mean, that to me, like in parallel process, is how families should be feeling. Because if you have system professionals that don't trust each other and don't talk, that's not being a very good role model for families that are involved. So I love all of those things that came out. The books were, I mean, it seems like a really little thing, but kids loved the books and parents loved getting the books, and it was just a nice thing.
They really did. We must have had 200 goodnight moons.
I know. We purchased them through Court Improvement one time, and I personally, with our administrative person had to go, this is a long time ago because it was Barnes and Noble. When people bought books not off Amazon, and we went and we broke the cash register at Barnes and Noble because we bought so many books. But it was super fun to see kids get, you know, the books, and they were at court. And but like, that's a good example. Through the regional conferences, we did education about like why kids can go to court, and tried to have discussions about like they already know what happened in their families. So like having them come to court, there's a lot of pushback about, you know, like we will re-traumatize them if they hear these things. And we were trying to explain like they lived these things, and it's much scarier to have like this ominous group of people making decisions about your life. So we could have those discussions, and then figure out the practicalities in those teams about getting kids to court. Who's going to bring them? How long are they going to stay? What if you wanted to talk about things? But all that happened because the judges in those districts would convene a meeting, and they would have those discussions.
West Virginia's Court Improvement Board also purchased books for courts, and one of them actually had the title, they had Appalachia in it, which is of course our area, so they were really culturally appropriate. And they did the cutest thing. They had these little coloring books, and they gave them colored pencils in the coloring books, and the coloring books were all affirmations for the children. It's like, you are super, you are, you know, you are great. And they were given out, and I gave a bunch of them out. We got a lot of them. They handed me like cases of them at the Handle with Care conference, Cindy did. And so I started handing them out, and it was the same kind of thing. They thought that could be really a good way to make children feel more part of the process, and it be less intimidating and more relationship building. And they're really cute books, and I'm really proud of them for doing that.
Very neat.
It was also nice to see how parents interacted with their children in the courtroom.
Mm-hmm.
And sometimes the parent would be holding the book, and the child would be looking at the book during the court hearing while sitting on the parent's lap. It all mattered. It all made a difference.
Well, it kind of reminds the professionals of the humanity of folks. I will never forget, in a drug court hearing, in a dependency drug court, we had a toddler that started to have like the traditional meltdown because they'd had it with the day. And all of these professionals who talk about what kids should do and be like just lost all their sense, and nobody knew what to do when the kid was having a tantrum. And the next time we had drug court, we were like, this is what it's really like to be a parent of a toddler. Like, you know, we had judges, attorneys, therapists, treatment providers, because the whole team was there, and this kid was having the ultimate meltdown, and almost everybody was doing the wrong thing. They were like trying to talk the kid out of having the tantrum. And finally, Judge Heidemann, it was his court, just scooped the kid up and put her on his lap, and she sat up there for the rest of our hearing. But like, it was such a humanizing moment to like have the whole team see the kid there, and that this is how toddlers behave, and this is why it's difficult. And those things I think are so important.
You know, I should mention too that if you're in a jurisdiction where a judge doesn't want to meet, that doesn't mean that other people can't meet. You know, the county attorney the prosecutor could convene a meeting, the department could convene a meeting, the attorneys could convene a meeting. You know, if you don't have a judge that wants to participate, others could still convene and meet and still do some of the same things. Other questions? Is it okay if I ask?
I've got another one. Oh,
sure.
Yeah, go ahead.
Go ahead. No, go ahead.
Yeah. So, well, earlier you were discussing the judicial ethics code, and how it encourages collaboration and engagement I'm curious if there are any limitations to the role that a judge can play, in these sorts of community initiatives within that ethics code that we should be aware of in terms of not, asking judges to play certain roles within these conversations, or anything that we should know, again, just so that we don't, as we engage or try to bring stakeholders together, including the judiciary, to make sure we're not putting them in awkward positions or unethical positions.
Well, that's a good question too. You just can't talk about specific cases. And even if you talk in generalities, if you mention things that everybody knows involves a particular case, then you may get in a little trouble. And our folks were pretty good about that. But when I left the room, maybe they would talk. But it's just really important that you don't talk about specific cases at these meetings. Now, there may be a time when a judge wants to convene the lawyers and the caseworker and other professionals on that case. That's a separate issue. But when it comes to these collaboration teams, you just have to stay away from specific cases. But you can certainly talk about issues that affect specific cases. A lack of a family support worker, or a lack of in-home services, or difficulty with foster care, or making sure that an IEP is addressed. Those kinds of issues you can certainly talk about. And as I mentioned, the new code is fairly liberal in terms of encouraging these kinds of teams and meetings. It even goes so far as encouraging judges to cooperate with legislatures. Used to be 20 years ago, they didn't want judges talking to representatives or senators in their state because they were concerned about ethics issues. Now judges are looked upon as educators, so to speak, who can provide information to those that pass legislation. So the new rules really are intend for courts to be interactive with the community.
And you can't fundraise. That's the other. You
Still can't
raise
fundraise,
money.
right? Still can't fundraise. And some judges are like, there was a judge from a small town in Nebraska. He wouldn't let his daughter sell Girl Scout cookies because he was worried about what the community might think. I'm not sure you're going to get in ethics trouble for that if your daughter's selling Girl Scout cookies. But he was super careful about it.
Were you going to ask a question, Larry?
I can't
You were
remember.
saying something.
Oh, yeah, I was just curious what other who are part of this call, where they were from and what their role was. If they want to put it in the chat or just unmute. If you're comfortable doing that.
Hi, my name is Jeannie Lumpkin. I am Program Director for Project SAFE in Buffalo, New York for Best Self Behavioral Health.
Thanks for joining us. Did all the snow melt yet?
It has indeed.
Oh,
we are
good.
down to absolutely positively nothing on the ground.
Wow. That was unbelievable.
It was.
Oh my God. Well, it's a beautiful city. I've been there once.
Well, you'll have to visit again.
I'd like to.
And thank you for your perspective in regards to everything. So I've been listening and there's so much that I can agree with. Our programs here in regards to family court and family treatment court are pretty similar, but it's good to hear other perspectives as well.
Well, thank you for joining us.
You're welcome.
Do we have others that?
I think Gloria put in the chat. She's from Farmington, New Mexico, Capacity Builders. And they've got snow there too. So
Wow. How far are you from Albuquerque?
3 hours.
Oh, okay. I've been to Albuquerque and Santa Fe. Beautiful, beautiful state. And then there's somebody else I see.
Hi, I'm Michelle O'Brien. I'm from the National Center for State Courts, and just wanted to kind of listen to what you guys were doing. We have developed something called Upstream, and it's mapping out child welfare processes in court, trying to look further upstream at prevention and what people need in the community so they don't enter our system. So I just wanted to kind of listen, and it's really based on what you were talking about with judicial leadership and community involvement and collaboration. So just wanted to listen to see what you had to say. So.
Well, thanks for joining us. I did a project with the National Center for State Courts during the pandemic, assessing the success or failure of Zoom hearings. Was interesting. They just kind of observed for about 3 months as part of their ongoing assessment. Yeah. Well, you guys do good work.
Well, thanks. And what state are you from again?
Nebraska.
So Nebraska is one of our pilot states for Upstream. So we'll be coming to work with you guys.
Good.
Yeah.
Anybody else?
Well, I'm Karen Yost. I work for JBS out of West Virginia.
And we got to meet in West Virginia. All right. Other questions, comments?
I've got another question, actually.
Sure.
I think I'm full of questions today. So Judge Gendler, I'm curious about, so in your experience with Through the Eyes, and this might be a question too for you, Michelle, I'm curious if you all have found sort of low-hanging fruit, in terms of changes to system changes that many stakeholders agree on and are easily achieved to support children versus those that were maybe a little bit more complicated to get to. I'm curious what that's looked like in your experiences.
So here's some examples of things that we thought were fairly easy to address. We made sure that every parent was represented before they came to court. If it looked like they were not entitled to court-appointed counsel, then that would change later on. But everybody had a lawyer before they came to court, and everybody had a lawyer in that mediation session. That was one thing that we did. Another thing that we did that was pretty easy is we handed out to parents at that initial mediation session before their first court hearing a list of who the providers were that were contacted to assist with phone numbers and email addresses. And we made sure that visitation was arranged before they walked in the courtroom, to be honest with you. And typically the visits had already occurred before they came in the courtroom. The other thing that we made sure of that we were doing, but we really tried to make sure we never deviated, is if there was a removal, there would be a hearing within 7 days. No more than 7 days from the, and I should add that during that process, if it looked like a child or children could return home before that 7-day period, that there were supports in place and that occurred. So there were occasions when we came to court for a removal hearing and those kids were already home, but we still had the hearing to just discuss what supports were in place and what the next steps would look like. One of the other things that we did is we made sure we appointed CASAs at the beginning of the case. Sometimes we had waited until it was progressing towards adjudication. We appointed them right at the beginning, just as we appointed the lawyers. Again, to try and keep things moving along. And a lot of the other things that were low-hanging fruit really involved the court calendar, making sure that we had a pretrial conference with the lawyers 2 weeks after the initial hearing. And at that pretrial conference, we would discuss the time frame for what would occur next and when. So we tried to make sure that we docketed those different cases in a timeline that made sure that we weren't forgetting anything, but at the same time move that case along. So that was some of the low-hanging fruit that we addressed right away. The other thing you had to make sure that parents had food and housing. And so those were, there was an umbrella organization that was started in Sarpy County called Lift Up Sarpy, which kind of was a result of all these efforts. So just things like making sure that there was food in the house, and that the place they were living at was safe and clean. Those were some things that we did right away that we probably didn't notice initially, and we should have. So I don't know if that answers your question or not, but there's a really, Jenny and I were at a conference in DC in April, and we went to a presentation from Trenton, New Jersey. And it was a fascinating presentation. When they remove children, before they do anything, they make sure a parent has safe and secure housing and put those kids with the parent if they can. 2 years out, 95% of those families were still in that housing and doing well. So we know that housing is really an important issue for folks.
Well, and that was another good example of like collaboration, like they got like local, like property owners involved with housing and HHS, like they like came together to solve this problem. So yeah, housing first, Kim. Yeah, it's a housing first model. But I mean, I feel like having those conversations, like one of the things she talked about is they realized that it's really hard when you get a housing voucher to find an actual place. So they had basically, I'm calling them a realtor, but they were like a coordinator that helped them figure out like, these are the places that are open. These are the places that go with your voucher, like things that you only know if like you have conversations with folks who like work on the front line and are experiencing those things. So it just, you can't be like all getting together and talking through, you know, having like the judiciary and the systems and the caseworkers and the providers and everybody in the same room, like with Through the Eyes is the same thing. It just made such a rich conversation because there were people actually doing the work, you know, speaking to, you know, people that are trying to make the policy changes or procedure changes.
One other thing I want to mention in response to Carlos's question, as part of my career, I would go to the penitentiary and meet with inmates who went through the system as children and then adults. And the one thing that was really impressed me more than anything was none of those folks trusted the system as children. They never felt they could speak. They never felt they could trust the judge, their guardian ad litem, as parents, their lawyer, their caseworker, their probation officer. They trusted volunteers because they knew volunteers weren't getting paid. So in terms of low-hanging fruit, one thing that we tried to emphasize, and I hope we were able to do it, is to try and create a trusting environment where parents trusted the system, because if they didn't trust us, nothing we did would make a difference. So at that mediation session, that initial session, people made sure that parents understood what the plan was, who the caseworker was, the therapist, the guardian ad litem, the county attorney's office, who all the players were in the system. And then during that initial hearing, I would ask if they had any questions and if they understood the process and understood what was going to happen next, and if they disagreed with something that might happen next. And that was probably as important as anything we did, because it eliminated some of that mystery and it hopefully encouraged open dialogue. I may not agree with what they said. I may not agree with what they want, but it was awfully important that they have a chance to express it. So we found that by doing that at the initial hearing, really reduced the anxiety and mystery about what would be happening next in the system. You're muted.
I'm never gonna get it. I'm never gonna understand time zones, and I'm always gonna talk over my mute. I think looking at the time, just thinking about wrapping up, thanks for everybody who joined us. We knew when we launched this that it's like a super busy time. And again, you're our inaugural group. So thanks for being with us. And thanks, Larry, for being our guinea pig in this process. Like I often rope you into.
Yeah,
So-
and if people want to contact me directly, lgendler@aol.com is my email address. Please feel free to do so.
And we're gonna put up, we've got a survey. Kat, do you want to put up those slides?
Yeah, sure.
And you can also, like, if you're thinking about this and you're thinking you want other technical assistance about one of these areas or something, you can email the OVC email, which is right there.
Oh, oops, sorry.
And if you want any of the resources that we were talking about today, if you would just drop your email in the chat, then we can make sure that you get those. And I think Kat just put did you put the
Oh,
link?
sorry,
for
I'm
the
typing.
survey?
I'm typing the
Okay.
link before.
Just gonna put the link for the survey in there. And we hope that you guys tell everybody about the office hours and are able to come to the next one. Okay, the survey link's in there. So if you would fill that out, that'd be awesome. So our next office hours is a grantee talking about animal assisted therapy on January 12th. So after the holiday break. And we're always looking for topics that you might be interested in or experts that you want to hear from. So Kat is on top of it. There's a suggestion form that she just put in the chat. So if you have suggestions for, topics or people you'd like to hear from, you can let us know. And on that note, you can put up the last one, Kat. There's the email again, if you want additional TTA or, you feel like you want to do anything further with this information, we can chat about that. And then there's our website on there, which we're really beefing up and retooling. So keep revisiting it because there's a lot of work going on there. But thanks everybody for participating, and thanks, Larry, for.
Oh, my pleasure. Happy holidays, Merry Christmas, and Happy New Year to everybody. Thanks for having me.
Thank
Thank
you.
you.
Bye.
Thank you,
Bye-bye.
everyone.
Bye, folks.